Many high-profile Ugandans have been arrested on the several occasions and held in prison for extended periods without being granted bail. Individuals such as Dr. Kiza and others have been denied bail, leading the public to believe that the judiciary has not delivered justice. In an interview, His Worship James Mawanda, the public relations officer of the judiciary, clarified that the bail is the pre-trial remedy and not an acquittal.
The applicant, who is the accused person, is expected to make an application to the court. And when the court listens to the application, all parties involved in the case are asked to make a point. That is the prosecution himself or his defense counsel, and then a decision as to whether or not to be granted bail is given. However, there are a number of factors to be considered before granting bail. One of them could be what's the nature of the offence with which somebody is charged. The other one will be is the person living within the area of jurisdiction of the court, for instance, where is his place of abode. Okay, then another consideration maybe, is he a repeat offender? You know, there are those notorious people. Okay, he has been into dead tomorrow, the other day, he has so many cases around. Thirdly, what is how sensitive the matter is.
He further stated that the decision to grant bail would deny arrest solely with the judicial officer handling the case, who also determines the conditions under which the bail is granted.
The decision to grant that bail or to refuse it is in the discretion of the judicial officer. And the terms or conditions which may be set are also equally in the discretion of the judicial officer. However, he will have considered all those factors and decide whether it is cash or not cash, or it is a deposit of a certain chattel, okay, or property. Could be a land title, it could be a vehicle which is movable, it could be something which will attract you back to court until the matter is disposed of. Oftentimes people mistake bail to be the decision of the court and determining the case. No.
His Worship James clarified while some profile cases take years to be resolved, while others appear to be fast-tracked.
When we talk about case backlog, the judiciary as an institution has a robust intervention to ensure those old cases are fast-tracked. You see? Now you may find that your case came yesterday, it's not as complex as others, and when it was cause-listed or a judge was allocated a matter, it became easier for them to fast-track it. Then there is this complicated case, okay, which by its very nature has to be taken through the steps. You know, justice hurried can also be justice buried. So we are conscious about some of those things, and we move forward systematically to ensuring that justice is delivered.
With the court fees often being unaffordable for the average citizens and persons with disabilities, His Worship Willie Atono, the Magistrate Grade 1 from the chambers of the Chief Registrar, clarified and addressed this concern.
And I think in that rule, in that regulation, if it eventually comes out, issues of cost, how much are they supposed to be paid, will be catered. But in terms of, for example, deaf people who must incur additional costs of an interpreter, the cost of interpreter is covered by the judiciary. The judiciary gets the interpreter, the judiciary facilitates, pays for that person's interpreter.